Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross LLC. I'm a practicing business attorney with over 15 years of experience of helping entrepreneurs start and grow their business. Today we're going to talk about the importance of operating agreements for single-member limited liability companies, which are also called single-member LLCs. A single-member LLC is an LLC that only has one owner or member. An operating agreement is an internal document for the LLC that outlines who the owner is, how much the owner has contributed to the LLC, how the LLC will be managed, and various other matters in connection with the LLC. It is an essential document for each and every LLC. Unfortunately, a lot of single-member LLCs in Massachusetts don't have an operating agreement because it's not required by Massachusetts law, and the owner thinks, what's the point? I'm the only owner, so why do I need an agreement with myself? And that's what I'm going to talk about today. There are at least 4 reasons why every single-member LLC should have an operating agreement, and we'll go over each reason today. Stick around to the end, and you'll get important insights and tips about clauses you should have in your LLC operating agreement, no matter how many owners or members you have in your LLC. And please, if you'd like to get more helpful legal tips, please hit the like and subscribe button below. It really helps the channel and lets me know you'd like to receive more helpful legal tips like this one. So let's get to it. The first reason for your single-member LLC to have an operating agreement is that it satisfies some of the necessary record-keeping requirements for your LLC. Now, an LLC is not a corporation, so it doesn't have as many record-keeping requirements as a corporation does. But there are a few requirements, and you want to make sure to comply with them in order to avoid having your LLC's corporate veil being pierced, which we'll talk about in a moment. One of the most important requirements, according to the Massachusetts LLC Act, which is MGL 156C, is that every LLC needs to keep a list of the full name and last known address for each member and manager of the LLC. An LLC operating agreement will satisfy this requirement because in the operating agreement, you'll identify who the members and managers are and their addresses. The list needs to be kept at an office in Massachusetts, which can be your principal office address, your resident agent's office, or some other address that you identify in the certificate of organization as the location where your records will be stored. Any of these are fine, but it has to be somewhere located in Massachusetts. Another requirement from the Massachusetts LLC Act is that every LLC, including single-member LLCs, must have a writing that sets out multiple items related to the LLC. First, the required writing must set out the amount of cash that each member is contributing to the LLC, either now or in the future. If a member is not contributing cash, but is contributing services or some other property, then the writing must state the agreed-upon value of the assets or services. Suppose, for example, you're starting up a single-member LLC that does business consulting in Massachusetts. Then your required writing must state exactly what you're contributing to the LLC in order to get it up and running, which should include at a minimum all the money spent in setting up the LLC, any money you're putting into the business bank account, any website fees you paid, and any other costs you spent associated with starting up the business. Second, the required writing must also state the times or events when the member is required to make additional capital contributions to the LLC. This is usually not a big deal, but the writing should state something along the lines of, quote, the member is not required to make additional capital contributions to the LLC except as deemed necessary by the member in his or her sole discretion, end quote. Third, the required writing must also state the member's right to receive distributions from the LLC and the times and events when distributions will be paid by the LLC to the member. By distributions here, I'm talking about when the LLC can pay the member a share of the profits or its assets. Many single-member LLCs don't pay their member a regular salary, but the owner only receives a share of the profit when the LLC can afford to pay a portion of its profits after its expenses have been paid. To comply with the Massachusetts LLC Act, the LLC should have a writing that states that the member is entitled to receive a distribution from the LLC when the member or manager determines it can pay the member a share of the profit as determined by the member or the manager in his or her sole discretion. You can also identify specific events when distributions must be paid by the LLC to the member, such as for paying quarterly estimates to the IRS or the Massachusetts DOR. Finally, the required writing must also state the events and situations when your LLC will dissolve and its affairs wound up. In other words, when do you want your LLC to shut down? The most common event, of course, is when the member decides to shut down the LLC and files a certificate of dissolution. But you can also specify other situations, such as when the member files for bankruptcy or passes away. No matter what the situation is, every LLC is required to have a writing that identifies all the situations when the LLC will dissolve and close its business. Now, the easiest way to satisfy this mandatory writing requirement is to have a written operating agreement with all of these details. Usually, every operating agreement will have sections that address members, managers, their addresses, required contributions, when distributions will be made, events of dissolution, and all sorts of other things. So by having a written operating agreement, you'll automatically satisfy some of your LLC record-keeping requirements so long as you keep the operating agreement in the required location in Massachusetts. And in my experience, if a single-member LLC does not have a written operating agreement, it won't have the writing required by the Massachusetts LLC Act, which significantly increases the risk of corporate veil piercing, which I'll talk about next. The second reason a single-member LLC should have a written operating agreement is to minimize the risks of corporate veil piercing, and it's intimately related to the first reason we just discussed. As I've talked about in an earlier video, most people who form an LLC in Massachusetts form the LLC in part to shield their other personal assets from the risks and liabilities associated with the business. But this protection is not absolute. If a Massachusetts court does not believe that your LLC is a real independent entity separate from you, it will allow creditors to go after your other personal assets to satisfy the debts and obligations of the LLC. The legal term for ignoring this separate entity shield is called piercing the corporate veil or finding alter ego liability. As I discussed in my earlier video, the way Massachusetts courts decide whether to pierce the corporate veil comes from a seminal 1968 case called My Bread Baking Company versus Cumberland Farm, Inc., as interpreted by a leading federal court case. In that case, the court identified 12 factors to consider when deciding whether to pierce the corporate veil, which are listed on your screen below. These factors are still used by Massachusetts courts today when deciding whether to pierce the corporate veil. I talked about these factors in detail in my earlier video, and I won't go over all of them again today. I'll just put a link to the video below. However, notice that two of the factors considered are whether the LLC is missing its required records or whether the LLC failed to observe its corporate formalities, such as by timely failing its annual reports and keeping records of distributions to its owners. If your LLC does not meet the requirements, this will count in favor of piercing the corporate veil and not treating your LLC as a separate entity. Now, here's what matters for single-member LLCs. It is much harder for a single-member LLC to prove that it's an independent entity separate from its owner and that the corporate veil should not be pierced. Why? Because many of the My Bread factors already count in favor of piercing the corporate veil and not finding that the single-member LLC is a real separate entity. Take a look at the second factor, which is whether there is pervasive control by the owner over the LLC. In a single-member LLC, the sole owner is, of course, going to have pervasive control over the LLC. And take a look at the ninth factor, which is the siphoning away of the LLC's assets by the dominant owner. In a single-member LLC, the sole owner is, of course, the dominant owner. And since all of the LLC's distributions will be made to the sole owner, this will be at best neutral, but it may also count in favor of piercing the corporate veil if you don't have the required writing about when distributions should be paid to the owner. The same holds true for the 10th and the 11th factors, depending on whether your LLC has a separate manager or whether the owner has other businesses that do business with the LLC. In light of this, it is essential for a single-member LLC to do its best to make sure all the other My Bread factors do not weigh in favor of piercing the corporate veil. And by having a written operating agreement, you will be sure to have the required writing that identifies the members, their contributions, when distributions will be made, dissolution, and various other matters that we just discussed. This will help satisfy the fifth and sixth MyBread factors and weigh in favor of not piercing the LLC corporate veil. You should also make sure to satisfy all your other LLC statutory requirements, such as filing your annual reports. I spoke about the importance of filing your LLC annual reports in an earlier video, and I'll post a link to the video below. Aside from your written operating agreement and your other LLC statutory requirements, you should also be vigilant about not intermingling business assets with personal assets of the owner and making sure that you have contributed enough capital for the LLC to operate. By doing all of this, you minimize the risk of having the LLC's corporate veil pierced as much as possible. Speak with a knowledgeable business attorney if you have any questions or you need assistance. The third reason for a single-member LLC to have an operating agreement is for business and estate planning purposes. One thing many single-member LLC owners never think about is what happens to your LLC if you die or become incapacitated. Unfortunately, without an operating agreement, your LLC will be governed by the default rules under the Massachusetts LLC Act. And under the default rules, your estate's executor, administrator, guardian, or personal representative can exercise all of your rights as a member in the LLC to settle your estate and operate the business. The problem with the default rule is that this process is not automatic. It typically involves Massachusetts probate courts, which are fairly slow moving and can take weeks or months to resolve, even when there's no disputes. This can kill your business, and business operations can freeze while the probate process plays out. Some typical problems include problems with accessing your LLC bank accounts, failing to pay payroll, vendors or landlords, lapsed contracts, and various other issues. If you're the only member and manager of your LLC and something happens to you, the business doesn't just pause, but will stall completely. Now you might be thinking, I don't care because I'm dead or incapacitated. But if you do care and you want to preserve your business for your employees and your family, this potential problem is fairly easy to fix with a written operating agreement. An operating agreement can name a successor manager directly in the agreement, and it can lay out exactly how your membership interests will transfer if you die or become incapacitated. The transfer should be automatic and will avoid any delays associated with probate court and will give your designated representative clear and immediate authority to keep things running in your business instead of waiting on a judge or the probate process. Here's a pro tip. Don't treat your operating agreement and your estate plan as two distinct projects or two distinct written agreements. Make sure that they are consistent. Your operating agreement and your will or your trust need to say the exact same thing about who takes over and how. I've seen situations where a will names one person to inherit a business, but the operating agreement says nothing or names a different person, and this inconsistency creates all sorts of problems and can cause the kinds of delay and disputes that you were trying to avoid in the first place. And make sure that your estate planning attorney and your business attorney, or whoever is drafting your operating agreement, speak with each other, or at the very least have reviewed the language in each other's documents to make sure that they are consistent. The fourth reason to have an operating agreement for your single-member LLC is to override some of the LLC default rules in MGL 156C, the Massachusetts LLC Act. As I mentioned earlier, Massachusetts does not require LLCs to have an operating agreement. But if you don't have one, your LLC will be governed by the default rules in the Massachusetts LLC Act, many of which are not appropriate or particularly favorable to a single-member LLC. Luckily, the Massachusetts LLC Act is very flexible and allows you to override many of its default rules in a written operating agreement. We just talked about one way of overriding the default rules by specifying what happens to the LLC if you die or become incapacitated. But here are some other Massachusetts LLC Act default rules that you should consider overriding with a written operating agreement. The first Massachusetts LLC Act default rule to consider overriding is with respect to the management of your LLC. Under the default rules of the Massachusetts LLC Act, the management of an LLC is vested in its members unless otherwise provided in an operating agreement. So if you want to have a manager of your single-member LLC, it must be stated in a written operating agreement. Now keep in mind that although the name doesn't sound very exciting, The manager of an LLC has a lot of power and authority to govern and operate the LLC. A manager is like the board of directors and the CEO of a corporation. The manager has the right to sign contracts on behalf of the LLC, incur debts and liabilities for the LLC, decide whether the LLC is going to pay distributions to its members, or do anything else in connection with the LLC. The only restrictions on a manager's powers in connection with the LLC are restrictions contained in a written operating agreement. So, if you decide to appoint someone else as manager of your single member LLC, you want to make sure to place strict restrictions on their authority and reserve some decisions for yourself as the sole member. Usually these decisions are important decisions, such as whether to require additional capital contributions, pay distributions, take on new members, or decide whether the LLC is going to dissolve. These restrictions are only binding on the manager if they're contained in an LLC operating agreement. The second default rule of the Massachusetts LLC Act to consider overriding is with respect to the member's right to receive distributions from the LLC. Under the default rules of the Massachusetts LLC Act, without an operating agreement, a member is only entitled to receive distributions from the LLC when the LLC dissolves, when the member resigns from the LLC, or in order to repay documented capital contributions by the member to the LLC that have not been returned. That's it. So, if you don't have an operating agreement for your single member LLC, the situations when you're entitled to receive a distribution from your LLC are pretty rare and not all that helpful for most profitable businesses. However, these default provisions can be overridden by a written operating agreement, and the operating agreement can specify when the members are allowed to receive distributions from the LLC. So in your single member LLC operating agreement, you want to make sure to state that the member is entitled to receive distributions from the LLC in such times and in such amounts as determined by the member in his or her sole discretion. That way, you make sure to specify that you as the member are entitled to receive distributions from your LLC, which is what every business owner wants when the business is profitable. The third default rule of the Massachusetts LLC Act to consider overriding is with respect to the assignment of your ownership interest in the LLC. By assignment, I'm simply talking about transferring your ownership in the LLC either by sale, gift, or otherwise by law. Under the default rule of the Massachusetts LLC Act, your ownership interest in the LLC is assignable in whole or in part, except as provided in a written operating agreement. This means that your LLC ownership interest can be assigned or transferred to another party or seized by a creditor unless it's explicitly prohibited or restricted by your LLC operating agreement. And there are lots of reasons why you might want to prohibit someone else from obtaining your ownership interest in your LLC without your permission. The most important one is to stop a creditor of yours from seizing control of your company and obtaining the right to manage your LLC or receive distributions from your LLC. To stop this, you want to make sure to have an anti-assignment provision in your LLC operating agreement that states that your ownership interest in the LLC can't be transferred or assigned to anybody else except by the express written consent of the member, and that any transfer in violation of this provision is void ab initio. That should be enough to override the default rule in the Massachusetts LLC Act and stop the unwanted transfer of your LLC ownership interest to someone else, particularly a personal creditor. There are a lot of other default provisions in the Massachusetts LLC Act that can be overridden by an operating agreement that are too complicated to discuss here and are far beyond the scope of this video. I highly recommend that you speak with a knowledgeable Massachusetts business attorney for help with your operating agreement. Operating agreements can be tricky, even for single member LLCs, and there are lots of important issues that need to be addressed. So there you have it. 4 reasons why it's essential for your Massachusetts single member LLC to have an operating agreement. First, an operating agreement will help satisfy some of your LLC record keeping requirements. Second, an operating agreement will help minimize the risk of having the single member LLC's corporate veil pierced. Third, the operating agreement will help with business and estate planning when you die or if you become incapacitated. And fourth, The single member LLC operating agreement will help you override some of the default rules in the Massachusetts LLC Act, some of which are not helpful for single member LLCs. I hope you found this information helpful. If you found it helpful, please like the video and share it with another Massachusetts business owner who has some questions about whether an operating agreement is necessary for their single member LLC. Thank you so much for watching. I'll see you in the next episode of Small Business Legal Tips.